Hello and welcome to Byju's Exam Prep IAS. Let's get started and look into our daily quiz. Let's look into the first question. Consider the following statements with respect to doctrine of sealed cover. It is the practice followed by the Supreme Court of seeking and accepting information from government agencies in sealed envelopes that can only be perused by the judges. The use of sealed covers to produce evidence derives its legitimacy from Code of the Civil Procedure and the Code of Criminal Procedure. Which of the statements given above are correct? The answer to this is one only. Why have we taken this practice question? Because this article on the Hindu makes a reference to the sealed cover. Let us try and understand what are these statements. When you look into the first statement, yes, it is the practice followed by the Supreme Court. Not only the Supreme Court, it is also practiced in number of other cases, even by the lower courts as well, of seeking and accepting information from government agencies in sealed envelopes that can only be perused by the judges. This basically means that you have some of the content that is given by the government. The other party would not be able to see this content. The government gives the sealed envelope to the judges, to the courts, and only the judges would be able to view this particular content, which is called as the sealed cover doctrine. So what is the sealed cover doctrine? Some of the evidences, documents will be given by the government to the Supreme Court or to relevant courts, and only the judges would be able to read it, since it is covered in an envelope, in a sealed envelope, and given to the judges. It is called as the sealed cover doctrine. So the first statement is right. When you look into the second statement, the use of sealed covers to produce evidence derives its legitimacy from the Code of Civil Procedure and the Code of Criminal Procedure. This statement is wrong. Its legitimacy is derived from the Indian Evidence Act of 1872 and the Supreme Court rules. So remember, it is not Code of the Civil Procedure or the Code of the Criminal Procedure or the Criminal Procedure Code, but instead it is the Indian Evidence Act and the Supreme Court rules. It is through them that they derive their legitimacy. There is no one specific law. It is Indian Evidence Act as well as the Supreme Court rules from which this sealed doctrine is emanating from. If we look into the Supreme Court rules, Rule 7 of Order 13 of the Supreme Court rules specifically states no party or person will have the right to receive the documents that the Chief Justice directs to keep in a sealed cover. The only exception to this is when the Chief Justice himself orders production of such a document to the opposite party. As part of the assignment, you have to put on the comment section which section of the Evidence Act are we speaking about. We did discuss about Rule 7 of Order 13, but which section in the Evidence Act speaks about the sealed cover doctrine? It does not speak directly about it, but there is a reference to this concept. Which is that section is what you have to put on the comment section. So basically, if the government feels that some of the documents are important and this should not be viewed by the other party because of the security, national security, public order, so on and so forth, that is when the documents and the evidences will be given by the government to the respective coach. Now let's look into the next practice question. Consider the following pairs. We have exercise on one side, the participant nation on the other side. Dharma Guardian, India and Japan. Garuda, India and Indonesia. Sampriti, India and Bangladesh. Surya Kiran, India and Nepal. How many pairs given above are correctly matched? The answer to this is all four pairs. Why have we taken this practice question? Because this article on the Hindu makes a reference to the Dharma Guardian. All the matches that we have here are correctly matched. Yes, Dharma Guardian is between India and Japan. Garuda is between India and Indonesia. Sampriti is between India and Bangladesh. And Surya Kiran is between India and Nepal. These are all the military exercises between India and the respective countries. So basically, they help in interoperability. They will know how to understand certain advantageous positions when it comes to the operations of the military, and at the same time one country will learn from another country. This will further give boost to the relationship between India and the respective countries. We also have other military exercises as well. This includes Mitra Shakti between India and Sri Lanka. Then we have Vajrapahar between India and US, Yuddhabhyas between India and US, Shakti exercise India and France, hand in hand India and China, Simbex India and Singapore, Shakti between India and France. As part of the assignment, you have to put on the comment section what is the exercise between India and Thailand called as. Please put it on the comment section. Now let's look into the next practice question. With respect to Unlawful Activities Prevention Act or UAPA, which of the following statements are correct? Governments can only declare organizations and not individuals as terrorists. National Investigation Agency should take prior permission from the respective state police chief to attach the proceeds of terrorism. Which of the statements are correct? The answer to this is none. Why have we taken this practice question? Because this article on the Hindu makes a reference to Unlawful Activities Prevention Act of 1967. Let us try and understand what are these statements. When you look into the first statement, government can only declare organizations and not individuals as terrorists. This statement is wrong. Why? That is because when you look into the original act only envisaged the terrorist organization, which basically means a group of people come together and they form one of the organizations. So that was declared as unlawful by the government of India under the UAPA. So when you look at the original act, it was like that. However, amendments were made in the year 2019. In the amendments, even individuals could be designated as terrorists. When you look at the original act, individual could not have been done so. But when it comes to the 2019 amendment and the present status, both individuals and organizations can be tagged as terrorists. So originally it was only terrorist organization. Now both individuals and organizations can be declared as terrorists. So the first statement is wrong. When you look into the second statement, National Investigation Agency should take prior permission from the respective state police chief to attach the proceeds of the terrorism. Now, they don't have to take the permission from the respective state governments. To look into the amendments, let's read into it. We have the words in which such property is situated, make an order. The words in which such property is situated or the where investigation is conducted by an officer of National Investigation Agency with the prior approval of the Director General of National Investigation Agency, make an order shall be substituted. This basically means that they need not have to take the permission of the respective state heads to confiscate or attach the property. This is the amendment that is made in 2019, and the amendment also goes on to say that apart from terrorist organizations, what they would also be able to add is individuals into this particular structure. Now let's look into the next practice question. Fathul Mujahideen, a military manual, was commissioned during the rule of Abul Hasan Qutub Shah, Aurangzeb, Humayun, Tipu Sultan. The answer to this is Tipu Sultan. Why have we taken this practice question? Because this article on the Indian Express makes a reference to Tipu Sultan. Let us try and understand what is this concept of Fathul Mujahideen. This happens to be a military manual as given in the question. So this was a military manual that was written by Zainul Abedin Shustri at the instruction of Tipu Sultan. So Tipu Sultan asked this person Zainul Abedin Shustari to write this military manual, and he produced this Fathul Mujahideen. So basically when we speak about Tipu Sultan, he was the king of Mysore. Tipu Sultan used rockets in the battle with the British Army during 1792. So how exactly these rockets will have to be used, how exactly these operations will have to be conducted was given in this manual called as the Fathul Mujahideen. There are other important facts from the preliminary examination point of view with respect to Tipu Sultan. Tipu Sultan fought against the Marathas between 1775 and 1779. Tipu signed a peace treaty with the British in 1784. British attacked Tipu Sultan when the ruler of Travancore was attacked by the army of Tipu Sultan. The ruler of Travancore was the ally of British, and in 1792 Tipu signed the Treaty of Seringamapatnam and he lost all of his dominion to the British. It is the Battle of Pullilur or the Battle of Perambakam, which took place in 1780 at Pullilur, the city of Kanchipuram in the present-day Tamil Nadu, as part of the Second Anglo-Mysore War. Tipu defeated Lieutenant Colonel William Bailey of the British East India Company in the Battle of Pullilur. These are some of the other important facts that you have to remember from the preliminary examination point of view. Now let's look into the next practice question. Consider the following statements. Jawaharlal Nehru was in his fourth term as the Prime Minister of India at the time of his death. Jawaharlal Nehru represented Rai Bareli constituency as a member of parliament. The first non-Congress Prime Minister of India assumed the office in the year 1977. Which of the statements given above are correct? The answer to this is 1 and 3. This happens to be a previous year question from the year 2007. When you look into the first statement, yes, the first statement is right. Jawaharlal Nehru became Prime Minister in 1947 for the first term, followed by an election in 1952 for the second term. Then election again took place in 1957. He became Prime Minister for the third term, and finally, after winning 1962 elections, he became the Prime Minister for the fourth term, and he died in 1964. He never represented Rai Bareli, but instead he represented Fulpur constituency near Allahabad in Uttar Pradesh. So the second statement is wrong. The third statement is right. That is because Morarji Desai served as Prime Minister as the head of multi-party front Janata Party, India's first non-Congress government. So statement 1 and 3 are correct. So the answer to this would be D. Now let's look into the fact of the day. The fact of the day for today's discussion is Special Marriage Act. Let us try and understand what is this concept of Special Marriage Act. When two individuals from the same religion, if they wish to get married, they will get married under their personal laws. Let's say for example, we have two Hindus, a man and a woman who want to get married. In that case, they would get their registration under the Hindu Marriage Act of 1955. What if two individuals from the Muslim community will have to get married under the personal laws? What we have is the Muslim Marriage Act of 1954. In this case, what if there is a person from one religion wants to get married to a person from another religion? In this case, what we have is a Special Marriage Act to accommodate two individuals so that they can engage into a wedlock process. What we have is the Special Marriage Act. So when we have the personal laws, there are personal laws, but if two individuals who are from different community, if they want to get married without converting to another religion, that is where the Special Marriage Act comes into picture. So basically, the Special Marriage Act was passed by the Parliament back in the year 1954. The applicability of the Act extends to people of all faiths, Hindus, Muslims, Sikhs, Christians, Jains, and Buddhists across India. However, when it comes to the Special Marriage Act, there are also restrictions that are imposed on the individuals. What are these restrictions? These restrictions are clearly given in Section 4 of the Special Marriage Act. What are these important pointers? Let's say, for example, there is one of a person who is already married. Can he again get married under the Special Marriage Act? No. So even if an individual wants to get married under the Special Marriage Act while he has a spouse who is not divorced, that cannot happen under the Special Marriage Act. So the first criteria is neither party should have a living spouse. Either they should be dead or they should have divorced such a person. So if they are in the wedlock, if they are in the marriage without divorce or they are not dead, they cannot get married under the Special Marriage Act. Added to it, valid consent is very important. What is consent? That both the boy and the girl will have to say yes, and they should not have unsound mind as well. They should be able to give consent to it. So only when a valid consent is given by an individual, that is when it can be accepted under the Special Marriage Act. When it comes to the Special Marriage Act, the male should have completed 21 years of age and the female should have completed 18 years of age. These are some of the criterion that has been put up under Section 4 of the Special Marriage Act. However, there is another thing as well. If they fall under the prohibited relationship, that is also barred as part of Section 4. Then we have something called as the Section 5 of the Special Special Marriage Act. What is the Section 5? As per Section 5 of the Act, the parties are required to give notice in writing to a marriage officer of the district in which at least one of the parties has resided for at least 30 days immediately preceding the notice. So what should they do? A man or a woman will have to give notice to the marriage officer that they would want to get married under the Special Marriage Act. Once this notice is given, the marriage officer will put a notice for the next 30 days. So this is a period where any person would be able to oppose their marriage. Why is this clause put up under the Special Marriage Act? This is where we can go up to Section 4. What does Section 4 say? It gives certain limitations. That is, they have to be about 21 years of age. They have to be about 18 years of age. They should not have unsound mind. They should be able to give valid consent. They should not have a living spouse. So during this 30 days of notice, if any person feels that any of this is getting violated, that this particular person is less than 21 years of age or 18 years of age, that they have a spouse, in that case they would be able to oppose it. So the 30 days period is primarily given so that these two people are not cheating each other, and all the restrictions that are imposed under Section 4 is also taken into picture. So the 30 days is primarily to ensure that people can oppose if any of the limitations are getting violated under Section 4. So a Special Marriage Act is basically the one which allows parties to get married if they are from different communities. It is this that we have to understand with respect to this topic. So this is it for today. Thank you for watching. All the best.